Good evening. Welcome back. Chairman Sessions is traveling back to the Capitol, and while he will be here in time for this evening's vote, he asked that I begin the hearing on his behalf. Today, the Rules Committee will consider H.R. 3438, the Review Act of 2016, H.R. 5719, the Empowering Employees Through Stock Ownership Act, and H.R. 5461, the Iranian Leadership Asset Transparency Act. Currently, employees of companies that are not publicly traded can be required to include the value of stock-based compensation as income for tax purposes well before they generally have the ability to sell shares to pay the tax on such compensation. H.R. 5719 would directly benefit employees at startup companies by making it easier for them to share in their company's upside by including equity grants as part of their compensation, while ensuring income is deferred only until there's an opportunity for the employee to liquidate the shares, which would provide cash sufficient to pay the tax and the stock-based compensation. H.R. 3438, the Review Act of 2016, amends the Administrative Procedure Act to require administrative stays of the effective dates of new regulations imposing $1 billion or more in annual costs to the U.S. economy if litigation to challenge the regulations is brought within statutory specified time limits. Productive contributors to the economy should not have to face the choice between losing billions of dollars needlessly if they pursue successful litigation and the alternative of complying with new and illegal billion-dollar rules without a fight. The committee will also consider H.R. 5461, the Iranian Leadership Asset Transparency Act, which would require the Treasury Secretary to develop and post online a list estimating the funds and assets held by senior Iranian political and military leaders, along with a description of how they acquired the assets and how those assets are employed. The report would be posted on the Treasury Department's website in English, but also translated into the three main languages used inside Iran, and would be available in any of those forms in a way that it is easy to download and share. I'd like to welcome Mr. Paulson. What a dramatic arrival. You literally just showed up as your name popped up on my prepared remarks. So I want to welcome Congressman Paulson and Congressman Crowley are both joining us today. Without objection, anything you have in writing will be inserted into the record. We look forward to your testimony. I now would like to yield to the ranking member who's present, Mr.
McGovern.
McGovern from Massachusetts.
Thank you very much. And I don't have an opening statement. I just want to welcome our two witnesses, and I will yield back my time.
Thank you, gentlemen, for doing that. We'll go to the gentleman from Minnesota, Mr. Paulson, for any opening remarks he cares to make.
Mr. Mouth, thank you, Mr. Chairman. And let me just start by saying the tax code today is forcing many mid- and lower-level employees at startup businesses around the country to let a very potential lucrative opportunity pass them by. And it's because these employees have been granted stock options as a significant part of their compensation, which is a common practice for a business that is developing a very promising technology, but that is not yet profitable. And when the business succeeds and the time has come for an employee to exercise that stock option, oftentimes they do not have the cash necessary to make the related tax payment, which is due immediately from the IRS. As a result, employees are letting their stock options expire, missing out on thousands and thousands of dollars that could help them send their kids to college or prepare for retirement. And so my legislation, with Mr. Crowley as a co-sponsor as well, which I appreciate, the Empowering Employees Through Stock Ownership Act, addresses and fixes this problem by allowing an employee to defer their tax payment for 7 years or until there is a market for their stock, which they could then sell to get the money needed to pay the taxes. The bigger picture here, though, Mr. Chairman, is about making sure that the United States remains the global leader in innovation and promoting employee ownership. Many employees are drawn to startup businesses for the opportunity to work on the next innovative solution that can improve the lives of millions of people. They're also drawn by the chance to have some ownership over this idea. However, some are now choosing to instead stay at or go to a larger, more established company because they know that at a startup business, they could be faced with this unfortunate tax situation. To put it plainly then, the tax code could very well be preventing the development of the next life-changing technology. The Empowering Employees Through Stock Ownership Act will remove this deterrent and make it easier for individuals to chase their dreams and to seek new creative environments that could lead to the next innovative idea. The legislation is also designed to promote employee ownership, an issue that I have worked hard on for many years. Only those individuals at businesses where similar stock options are offered to 80% of their employees or will be eligible for the tax deferral provided in the bill. This provision will encourage businesses to offer more of their employees an ownership stake, as well as serve as an important guardrail to prevent companies that only offer stock options to a select few high-level employees from taking advantage of the bill. Importantly, the Empowering Employees Through Stock Ownership Act also contains several provisions that ensure only those employees that truly need tax deferral are actually able to obtain it. Individuals that own more than 1% of a business, such as the CEO, the CFO, and the 4 highest paid employees at a business, are not eligible for deferral. I'd ask my colleagues to join me in supporting this common sense legislation that will increase employee ownership and remove an unnecessary obstacle to American innovation. And thank you again, Mr. Chairman, and I yield back.
Thank you very much for your testimony. We'll now go to my good friend from New York, Mr. Crowley, for any remarks he cares to make.
Thank you, Mr. Chairman, and thank the ranking member who's joined us as well as both members of the majority and the minority who are here today to hear us, and I appreciate the time you've afforded us. And I will speak in favor of the positive aspects and the merits of the Empowering Employees Through Stock Ownership Act, and I want to voice my appreciation for Mr. Paulson in working in a bipartisan way on this issue. But I would also like to ask the committee to strengthen the bill before us today in order by accepting an amendment and making it in order on behalf of myself and Rep. Anna Eshoo to offset the $1 billion cost of the bill so that we can empower workers without saddling our children and grandchildren and great-grandchildren with additional debt. With respect to the underlying bill, I think all of us are growing increasingly concerned that far too many American workers have not been sharing in the success of companies that they have helped to make successful. This bill aims to address that issue by promoting employee ownership. Many startup companies do not have the financial resources that pay their employees competitive market-based wages, so they resort to offering their employees stock options. This gives employees the ability to own part of their company by purchasing company stock at a severely reduced price. Currently, when an employee acquires the stock, this stock is taxed as income. If the company is publicly traded, that's one thing. The employee can turn around and sell some of the stock that they have on a market to pay that tax while still keeping the bulk of their shares and remaining, in effect, a part owner of that company. But if the company is private, and that's the portion, that's the issue where this bill will address, not publicly traded, but privately held stock, employees can't go to a market because one does not exist to sell the part of their shares to help them pay the taxes that are due. These workers have to wait for a triggering event such as a stock buyback or the company going public before the stock is worth any real monetary value. But they are still forced to pay taxes on what we call phantom income of the fair market value of the stock at the time it is required. And if the company is successful, the value of the stock and therefore the tax could be pretty high. Now, if you're an engineer or a lawyer, you may have the wherewithal to pay that tax. But we're seeing so many privately held startups offering stock options to all their employees, including warehouse workers and call center technicians. And these employees may not have the cash on hand to pay the tax that would be required under the present law. Tax on an asset that doesn't even have actual tangible monetary value yet. So what this means in the real world is workers in privately held firms who help make their company a success are unable to take a personal stake in that success, simply because they can't pay the taxes due and so they can't acquire the company's stock. That means they lose out on a share of their income. They also lose out on the ability to become an owner in their company, and they lose out on part of the investment in their employer's long-term goal. This bill would allow employees of privately held companies to acquire the stock options offered by their employer in their compensation package, but defer any income taxes owed on those options for 7 years. It's deferred. Doesn't mean the tax doesn't get paid. It's deferred for 7 years, or until a triggering event occurs that makes the options worth real money, monetary value at that time. Besides making it easier for low-wage workers to become owners in their company, this bill encourages companies to offer more stock to more workers. We do this by stating that to obtain, and I appreciate Representative Paulson's pointing this out, To obtain these important recruitment and retention benefits, a company must offer at least 80% of their full-time workforce the option to own stock. Additionally, as Rep. Paulson has said, this 80% employee participation number excludes the CEO, the CFO, and the 4 highest paid workers in the company. In small startups, excluding senior management and mandating an 80% employee coverage test ensures that more employees and those further down the chain of command will be offered the ability to share in the success of that company. While this bill enjoys the full support of the National Venture Capital Association, TechNet, and the Small Businesses and Entrepreneurship Council, as well as the host of other technology and innovation firms, this is not just a benefit for California's Silicon Valley or for New York City's Roosevelt Island. It's an incentive for all privately traded firms to offer stock options as a tool of employee retirement and retention of good workers, and for those workers to be empowered as owners of their own company. It is a good policy with bipartisan support. I do believe we can make this bill stronger, though, by making an amendment offered by myself and Congresswoman Anna Eshoo to offset the cost of the bill so the price tag is paid for now and not by our children and grandchildren in the years to come. My amendment would increase the oil spill liability trust fund tax by just 2 cents per barrel to 11 cents effective January 1st, 2017. The Joint Committee on Tax estimates that this would raise $1.036 billion over 10 years, fully offsetting the cost of the bill. For those who are worried about this offset increasing the cost of fuel for consumers, let me boil this down. If enacted, this 2 cents a barrel increase would, even if passed fully onto consumers, raise the price of a gallon of gas by 5 1,000ths of a penny. 5 1,000ths of a penny. If it is not enacted, we're providing a tax cut today, but leaving a $1 billion tab for the next generation, plus interest on tomorrow's debt. I urge the committee to make my amendment in order so that we can enact a good policy, one that we worked in a bipartisan way to bring before the committee this evening, and not leave the check for the next generation. And I reserve the balance of my time. And Mr. Chairman, before I yield back, I want to ask for unanimous consent to enter into the record a statement by Anna Eshoo of California in support of the underlying merits of the bill, but also the amendment that I've stated previously.
Without objection? So ordered.
Thank you.
Thank you. First of all, I'll open up quickly and just thank both of you for being here. It's pretty hard to find bipartisanship 6 weeks before an election, so I'm very impressed that we're actually acting in that manner, and this is certainly a good common sense idea that has considerable merits. I don't have any questions. I just want to congratulate you both for here. Do want to just quickly ask my friend from Minnesota, do you support the amendment as well?
Well, Mr. Chairman, we had a conversation in the Ways and Means Committee, and the amendment actually was ruled out of order because it was not germane to the bill. I would defer to the committee, but I don't think we should raise taxes on others to have a tax cut that's provided in this bill. And it is a deferral, by the way, Mr. Chairman, of a 7-year period.
Well, and speaking from somebody from Oklahoma, from an oil state, I'll reflect what I think the sentiments of my chairman would be from Texas. Probably going to be a hard sell to me, at least personally, but that's just my personal opinion. We'll go to our ranking member for any questions that she cares to pose.
Thank you, gentlemen. It's nice to see you both today. Let me start off with a statement of administrative policy. It's very short. The administration is committed to helping startups, boosting innovation, and growing the economy, and is willing to work with the Congress on fiscally responsible measures to achieve those goals. However, the administration strongly opposes H.R. 5719 because it would increase the federal deficit by $1 billion over the next 10 years. Failing to pay for new tax cuts is fiscally irresponsible. But, Mr. Crowley, I understand that your amendment would cure that.
Yes, Ms. Slaughter, it would cure it, and in fact would more than cure it. And I understand that my amendment was offered at the committee, which I offered at the committee for,
I
was found
see
not
that.
germane. But I
Right.
do believe that we should put aside the procedural issues here. It's all about, it has been scored at costing the Treasury $1 billion. Besides the benefits that this bill actually provides to workers within a private company, we can't ignore $1 billion debt being placed on our
course.
children and grandchildren. And so with all due respect to my friend, Mr. Cole, I think a 5/1000th of a percent increase, of a cent increase on the cost of a gallon of gasoline is less than minuscule in terms of helping to pay for this. I think the American taxpayer would appreciate the transparency of doing that and succeeding in both providing relief to these individuals and private companies, but at the same time providing relief to their grandchildren and great-grandchildren that they will not be incurring the debt that we're placing on them.
I really like the idea very much. You couldn't find a way to take that money away from that $20 billion that we give the oil industry to drill, could you?
Well, that's a much bigger pay for, and we can use that for
Well,
something
you
else.
just
Here we found something.
take a bit here and a bit there,
little
yeah.
bit here and there.
Okay. All right, I have no further questions, but I do support the bill.
Thank you, gentlelady. Gentleman from Georgia?
I ask unanimous
Please.
consent to put this into record.
Absolutely, without
Thank you.
objection. So ordered. Gentleman from Georgia? No questions, Chairman. Are there any questions from gentleman from
I
Ohio?
just wanted to say the quarterback from Oklahoma looked really good this weekend, and that's it. I yield back, Mr. Chairman.
What's the gentleman, are you running for some office or something? Aren't we at that time you don't want to be alienating anybody, particularly your friends? No, I'd be remiss not to congratulate my friend. You brought 15,000, I think, fans. It was an amazing crowd. This is the University of Oklahoma-Ohio State game, the number 1 and 2 programs, according to AP, since they started rating in 1936. And our good friends from Ohio put it on us pretty good. It was 45. No, you didn't get lucky, believe me. I was there the entire game. You weren't lucky. You guys are that good. And so just congratulations to my friend. And thank you for the fans. They were a great addition. They really were. Boy, we even lost the battle of the bands. I mean, I thought your band was outstanding. So it was great to host you there. We look forward to having another opportunity somewhere down the line. But you are
Chairman,
welcome
on
in
that-
Norman on any occasion.
Mr. Chairman, on that note, I would suspect that many of those fans arrived at the arena by car and by vehicle. If we had passed this bill early with my amendment, we already could be paying for the $1 billion.
I asked them repeatedly, did they want higher gas prices? But none of them would consent to it.
I have a feeling if we ask
Even
them
for
for
a
a
worthy cause
five-
like this, they thought maybe that they shouldn't be paying for another tax rate.
5/1000ths on a cent, I don't think they would mind that much at all.
Well,
Nah, the game would go on, and
every time
I think
we work-
Oklahoma will still lose, but we'd be paying off the national debt.
every time we work hard to try and lower the price of gasoline by producing more, you guys think of some new way to jack it back up for the average guy. I don't know how you do it, but we'll keep producing. We'll keep making America energy independent. We'll still work to try and make sure you've got as cheap a gasoline as possible, despite all the federal regulations. But please don't work against us. Just let us keep working for you. Are there any other Republican questions? My friend from Massachusetts.
No, I would just say that I thank the gentleman for being here. I support Mr. Crowley's amendment. And Mr. Paulson, I mean, you talk about not wanting to ask the taxpayers to pay for tax cuts, but when you increase the deficit by $1 billion, we end up paying for it anyway. And this amendment may not have been germane in your committee, but one of the things about the Rules Committee is we waive rules of germaneness all the time. We fix it. In fact, on a regular basis, the rules are waived, and everybody seems to have no problem with it. So if there's the political will here, we could do it and have a debate, a vote. And if people don't want to vote to offset it, they don't have to. But I think we can make it in order. And again, thank you for being here. I yield back.
Does the gentleman from Florida have any questions?
Thank you very much, Mr. Chairman. I associate myself with the remarks of Mr. McGovern. Just for reference, this year alone, the Ways and Means Committee has marked up nearly $54 billion worth of unpaid-for tax cuts. And my friends on the other side often claim to be the fiscal conservatives who, it seems to me, want to cut into the deficit, but with these double standard offset examples, isn't it more likely that they aren't the budget purists, or they claim to be, but rather they like to spend money on the things they like, and then when Democrats want to spend money on issues of consequence as they perceive them, public health, for example, then my friends on the other side complain about the deficit. Let me ask both you gentlemen, and it's my only question, at least for the moment, how will this legislation help lower earners at a privately traded company if they choose to exercise their stock options that are a part of their compensation? You get my drift?
Well, they can only, if a market doesn't exist for them to sell their stock, they don't benefit, they can't. And that's why we're asking for this legislation to defer that payment of tax for 7 years. In the event that one of two things happens, either the company goes public and then the stock can be sold on the public market, or some other event triggers that, including a stock buyback, for instance, which would give a monetary value to that stock itself. And then the employee, it could be someone who just answers the phone, who's bought into the company stock, would have an ability then to sell a portion of that stock to pay the tax on that, but still retain ownership in much the same way that a publicly traded a company, a person who works for one who owns stock and that can do that.
Okay, Mr. Paulson?
Well, and I'll just add, if you do work at a public company, you can exercise the option and pay the tax because you can sell your stock on the open market to cover the tax. But the trend has been at startup companies to remain privately held for a longer period of time now, for a variety of reasons, I guess. And so we want to make sure that employees in particular that work at private companies are going to have more flexibility and latitude to essentially keep those talented folks at those types of companies and not see those stock options just pushed to the wayside or never exercised at all simply because of the way the tax code is set up.
And Congressman, I would also add, Congressman Hasty, that in the event, after the 7-year period when, if an event does take place, it's quite, the hope is that the company will be successful. And it gives more of an incentive in terms of that ownership and the individual to actually want to see that happen. So I think it really benefits lower-rung workers, given this option. And that's why, and also ownership, investment in their own company. And I think that's something we should all be striving for.
All right. Thank you, Mr. Chairman.
Gentleman from Colorado is recognized for any questions he cares to put to our guests.
Yeah, two questions. Great idea. Thanks for bringing it forward. Very important in ensuring the egalitarian sharing of ownership of companies. I just had two questions. First one, Mr. Crowley, your pay for, what is the exact match with the cost? Does it actually reduce the deficit on top of the cost, or is it the exact match?
It could potentially.
Or in terms of how it's been scored, I guess.
Number here. The official score of the bill is $1.031 billion, and my amendment would raise $1.036 billion, so it would slightly reduce the deficit as well.
Okay, essentially identical, so it's fully paid
Yes.
for. My second question was, did you? I think is in the testimony. There's the top 4 people in the company were exempted for the highly compensated 4 people. Just wondering how kind of that was arrived upon, and in some companies it might be, I guess the purpose of my question is, why isn't it kind of a compensation level rather than a number of people, like people making above $300,000, $500,000, $1 million?
Good question, and I'm sure Mr. Paulson would respond as well, but I think the goal here was to ensure that this was more egalitarian. In other words, that folks in the lower rung would have an opportunity to have ownership in the company itself, and maybe it's not an oversight, but more of a, we just think that the CEO and the top 4 individuals in the company are being paid a higher wage or profiting more from that. But I'll let my colleague.
But I agree with that entirely, the concept. So I guess what I'm more worried about is, it depending on the size of the company, numbers 5, 6, and 7 might also be highly compensated executives. I don't know why it's not. So Mr. Paulson, maybe you can address kind of how you came up with 4.
Thank you, Mr. Chairman, and Representative Polis, just to clarify, my understanding is the way we crafted it in this manner is because the SEC typically uses the guidelines for the controlling structure of a company for that top for the CFO, CEO, and, the top 4 highly paid folks. We're kind of following that model or that guideline essentially.
I would just suggest it might be a way, as the bill goes through the process, to get the cost down of the bill, if you look at some sort of absolute test of compensation and, a cutoff point, whatever that might be, $500,000 in annual compensation. So employees above a certain level might be exempt, and, that may pull in numbers 5, 6, and 7 in some companies. In other companies, in some you might have reasons where number 2, 3, and 4 are not even in that because they're not making a lot of money if it's a very small shop and they want to get the compensation out. So I don't know if that's, something you can explore as you look at reducing the costs as this goes through the process.
And Representative Post, there's also a 1% ownership test as well, for a guy that, and we'll certainly look at that. Senator Warner and Senator Heller in the Senate bipartisanly are also advancing the bill there.
They're also what?
Advancing the bill
Yeah,
there.
great. No, great idea. Again, thanks for bringing it forward. There's a real need. I've seen these situations where basically people can't even accept ownership compensation because they'd be stuck with a tax bill, and unless the company's public, it's non-transferable. There's no way they could pay that. So great idea. Thanks for bringing it forward, and there might be some ways you can even reduce the cost of it because the whole thing comes down to cost, whether it's worth doing unpaid for, all that. I think everybody agrees it's a good idea. But if there's a way that can be reduced even more, hopefully it's something we could look into, and I'm happy to yield back.
Thank you, gentlemen. This closes the hearing portion for H.R. 5719. I want to thank both the gentlemen. If you have anything in writing, again, that you'd care to leave with our stenographer, I know that would be very helpful to her. So I want to thank both gentlemen and would call up Mr. Marino and Mr. Johnson.
Thank you, Mr. Chairman.
Thank you very much.
You got it. Sure? Okay. He's going to email it to you. Thanks.
I want to thank both of you for coming up the Rules Committee this evening. It's my understanding you'll be discussing H.R. 3438, the Review Act of 2016. So if we can, we'll begin, Mr. Marino, with you. And again, anything you have in writing, please get to our stenographer, and you're welcome for any opening remarks you care to make.
Mr. Chairman, Madam Ranking Member, and other distinguished members of the panel, thank you for the opportunity to testify before you today regarding H.R. 3438, the Require Evaluation Before Implementing Executive Wish List Act of 2016, or commonly referred to as the Review Act. I introduced the Review Act on August 4 of 2015, and the Judiciary Committee ordered H.R. 3438 favorably reported with an amendment on September 8, 2016. Mr. Chairman, the need for this legislation is clear. Nearly every day, Washington's regulatory system places new obstacles in the path of American jobs and economic growth. The biggest obstacle of all are new regulations that impose more than $1 billion per year in cost on the American economy. Struggling workers, families, and small business owners have every right to ask why regulations that cost this much are ever promulgated to begin with. Surely there are less costly measures that are effective and should be adopted instead. Those less costly measures would allow many more resources to be devoted to job creation and productivity investment. But billion-dollar rules are promulgated. Since 2006, there have been 26 in total. In recent years, their number has grown exponentially alongside the growth and reach of the regulatory state. Over the past 8 years, there has been an average of 3 each year. There were 6 in 2014 alone. This is one of the reasons our economy has faced so much difficulty achieving full recovery under the Obama administration's misguided policies. Making matters worse, when billion-dollar rules are challenged in court, regulated entities must often sink billions of dollars into compliance while litigation is pending, even if that challenge will ultimately be successful. Such was the case in Michigan v. EPA, for example, in which an Environmental Protection Agency rule for utilities imposed about $10 billion in costs to achieve just $4 to $6 million in benefits. That is, at best, about $1,600 in costs for every $1 of benefit. This is money for job creation and economic recovery we simply cannot afford to waste. But EPA and the courts allowed it to be wasted for years during successful litigation challenging the rule, because neither EPA nor the courts stayed the rule. The Review Act is a common sense measure that responds to this problem with a simple, bright line test. Under the bill, if a new regulation imposes $1 billion or more in annual costs, it will not go into effect until after litigation challenging it is resolved. Of course, if the regulation is not challenged, it may go into effect as normal. This is a balanced approach, and it provides a healthy incentive for agencies to promulgate effective but lower cost regulations that are more legally sound to begin with. I thank the chairman for working with me on this important legislation, and I request that the Rules Committee grant an appropriate rule that allows for expeditious consideration of H.R. 3438. And I yield back.
Thank the gentleman for his testimony. We'll go next to my friend from Georgia for any remarks he cares to make to the committee, and then we'll proceed to questions. So, Mr. Johnson, you're recognized.
Thank you, Mr. Chairman. H.R. 3438, the Require Evaluation Before Implementing Executive Wish Lists Act of 2016, or otherwise known as the Review Act, would automatically stay high-impact rules that a party challenges by filing suit in court. Simply put, this bill is yet another reckless measure designed to delay the implementation of the most important rules protecting the health, safety, and financial well-being of everyday people. Passage of this bill will only benefit the pocketbooks of the large corporations and the top 1%, while the American people will be left unprotected from corporate greed. Other than satisfying the insatiable thirst of the super wealthy for more and more profits to stuff into their already overflowing pockets, this bill is completely unnecessary and is not in the best interests of the greater good. Under current law, both courts and the agency issuing a rule may stay the effective date of a final rule, while agencies have broad discretion in postponing the effective date of a rule. A court considers several factors in deciding whether to stay a rule, including whether the party is likely to succeed on the merits. In 2009, the Supreme Court in Nicken versus Holder instructed courts to consider 4 factors when deciding whether to issue a stay. 1, whether the stay applicant has made a strong showing that he is likely to succeed on the merits. 2, whether the applicant will be irreparably injured absent a stay. 3, whether issuance of the stay will substantially injure the other parties interested in the proceeding. And 4, where the public interest lies. The Review Act would discard this very flexible and reasonable test in favor of an inflexible and unyielding requirement that agencies automatically delay the effective date for any rule exceeding $1 billion in costs that is challenged in court, regardless of whether the party challenging the rule has any likelihood of success on the merits, is actually harmed by the rule, or whether staying the rule would be contrary to the public interest. It is virtually guaranteed that every high-impact rule would be delayed through litigation challenges, regardless of whether the litigation is meritorious. Frivolous litigation would almost certainly create years of delays for these rules, which in many cases have already taken years to promulgate. But the bill would not just apply to life-saving rules that exceed $1 billion in costs that keep our air clean and our children safe. Rather, it would likely apply to transfer rules, which involve the transfer of funds for budgetary programs as authorized by Congress, such as transfer rules involving the Medicare program or the federal Pell Grant program, as the Office of Management and Budget has clarified. Lastly, Mr. Chairman, I oppose this bill because it is a dangerous solution to a non-existent problem. Any party affected by a final agency action may challenge that action in court, while agencies may also delay the effective date of rules on a discretionary basis. Professor William Funk, who's a leading administrative law expert, explains that existing law, quote, weeds out frivolous claims and takes account of both the cost of the rule and the benefits of the rule that would be avoided by granting the stay, end quote. Absent any evidence whatsoever that courts have inappropriately refused to grant stays, I'm confident that existing law provides adequate protection. In closing, I urge my colleagues to oppose this legislation and make in order my colleagues' amendments to this bill, and with that, I'll reserve the balance of my time.
Thank the gentleman for his testimony. Let me go first to you, Mr. Marino. Have you had, because I certainly have had instances of people coming to you and pointing out regulatory statements and pronouncements that have materially damaged their businesses and that have been allowed to stay in force while they were indeed, taking, or their organizations that they were part of were taking the regulatory bodies to court?
Of course, Mr. Chairman, I don't think there is a member of Congress that has not heard from a constituent, whether it's a mom and pop operation on the corner with groceries, or it's someone in this, the lack of steel industry that we have, or it's someone in the energy industry. We are wasting hundreds of millions, billions of dollars on this regulation to begin with. And there are two issues here. The issue is the waste of money implementing these programs with a positive outcome. And the second issue is Congress's responsibility to control the purse strings, not some unelected bureaucrat who really has no idea what's going on out there in hometowns like mine and everyone on this panel. That money could be used. I have no objection to the regulation and the agencies. At this point, I do have a real problem with agencies over-regulating as they have been, particularly in this administration, but also in Republican administrations as well. It's our responsibility in the House to control this. But with these companies, I came from industry. Okay, I started sweeping floors at 17 years old and worked my way up into management. And I know the biggest hindrance to creating jobs and doing research and development is regulation. We could be creating millions and millions of jobs, protecting the economy, protecting the environment. I'm a conservationist. I live out in the country. My kids and I drink water from the ground. No one wants cleaner air and cleaner water than me. But we are putting more and more businesses out of business, and we are widening the gap between Congress's responsibility of legislating, controlling the purse strings, and agencies and departments overreaching.
I couldn't agree more with my friend's points. I personally can just tell you, when I'm in my district, I have more complaints about regulation than any other thing, more than taxation, more than even national security concerns, because it's getting in the way of people's businesses. Now, this wouldn't pertain to your bill, but it's just an example I have to use. Literally today, I had a college president from a neighboring congressional district, and a guy I actually know quite well, former member of the legislature in Oklahoma, but he was telling me about a situation where they bring their honor students to Washington once a year for a leadership class, a week long. They always stay in the same place, which is an Embassy Suites in Alexandria. And because they always stay in the same place, he's now being forced to comply, to designate this as an an off-campus extended learning site department and has to file what the crime rate is for the 1 week that they're there in the city of Alexandria. He said, I don't know how I get that. I'm going to obviously ask the hotel. I don't think they would know. I don't think the Alexandria Police Department will probably return my calls. But, that's just crazy. That's just crazy. They're going to a motel. They use the same one every year. They like to put these kids in a historic city. You're close to Mount Vernon. You're close to where, and you have to now file a regulatory report with the Department of Education. So, and I appreciate the point that you made that this was not unique to one administration, because I really do. The same nonsense existed under Republican administrations. This really, to me, is a matter of bureaucracies creating reasons for them to exist and sometimes having no connection. So these kind of restraints and the restoration of responsibility to Congress, I think is a very important object to achieve.
I'd like to add one more thing. I've been here, this is my 6th year, and I see the talent that we have in the House on both sides of the aisle, Republicans and Democrats, where we work on issues that together. There's no one more qualified. There's no one more educated in the process, and there's no one more attuned to it than we Congress members who hear it from our constituents. It's our responsibility. It's our job according to the Constitution.
I didn't have any questions, but I certainly want to give my friend a chance to make any additional remarks before we move to questions he might care to make, because obviously we were sort of engaged in a dialogue where we agree, and my friend obviously has a different point of view.
Yeah, I think that discussion or that colloquy goes into issue one that we are involved with here in Congress, and that is whether or not we're going to have limited or no government as some would want, or are we going to have the kind of government that we were charged with presiding over in the preamble to the Constitution, wherein the framers put upon us the ideal to establish justice, ensure domestic tranquility, provide for the common defense, and promote the general welfare through our legislation. And through our legislation, the executive branch is charged with taking care that the laws be faithfully executed, and they do so through agency rulemaking. And so it's been a time-honored process that we have had in this country, which has gotten us to this point, which we're trying to deconstruct. And in my opinion, we're pretty much going too far with this effort to, as they say, rein in an out-of-control government. This government is not out of control, and it's manned in its executive agencies by people just like you and I who want the best for America. And like my friend, Chairman Marino, I believe that there's abundant talent here in this Congress to legislate appropriately, and I believe the same thing about the hundreds of thousands of people working in the federal government to make sure that the laws that we pass are faithfully executed. And with that, I will yield.
Well, thank you, gentlemen. I'll go to my good friend, the ranking member, gentlelady from Kentucky.
Thank you, Mr. Cole. Mr. Marino, you were referring, I think, to the MATS standard rule. Is that the one in Michigan?
Yes.
Let me say just a thing or two about that. You were referring that the time was excessive in trying to come to some conclusion?
I'm sorry, I don't understand what you're asking, please.
Because, well, I think that you referred to the fact that it took an inordinate amount of time because of this. Okay,
Yes.
well, after it was remanded to the D.C. Circuit, that just chose not to stay the rulemaking, pending court review, the ultimately requiring businesses to still incur the compliance costs during the review, correct? That is your issue.
Yes.
All right. Was able to quickly address the cost issues raised by the Supreme Court, and in December 2015, they upheld the rule. Since the case was only brought in July, from July to December, I don't know anybody who could reasonably say that was an inordinately long time for court. Also, despite nearly $10 billion of annual cost associated with the rule, the White House Office of Information and Regulatory Affairs estimates the rule's annual benefits to the country range between $30 and $90 billion, which I think is significant. And let me ask unanimous consent to put the administration's policy statement in and just kind of read from it here and there. The administration is committed to ensuring the regulatory process remains efficient and effective and is tailored to further statutory goals in the most effective manner. It points out that the court is already able to stay rules that are onerous or unnecessary. They have the discretion to change them on a case-by-case basis. And if this bill should appear for the president's signature, his senior aide would recommend that he veto it. Thank you. And let me also put in the record a number of people, business people practically, who are opposing this bill, that they believe threatens public health, safety, and billions in economic harms. They're talking about this bill doing that. The unnecessary regulatory delays imposed in H.R. 3438 would cost the U.S. economy billions of dollars, while endangering the public health and safety through delay of life-saving regulations, and would lead to needless litigation and delay.
Without
So
objection,
I
could the
believe.
gentlelady just
Yes.
quickly tell us what group it was? That said
This
that she did
is Coalition for Sensible Safeguards, consisting of over 150 labor, consumer, and environmental organizations, and the American Sustainable Business Council, which represents over 200,000 businesses.
I thank the gentlelady.
Hey, so, Mr. Marino, I appreciate your problems. I hope this will put your mind at rest. That it's not as bad as you think it is.
These are estimates that, you're talking about estimates. Do you actually think a factory shuts down even though it's a 6-month or a 1-year period? It's costing jobs.
No.
It's costing
It
taxpayers money to do this. And we're going to disagree.
I don't know how you can say that if it says it brings the government $90
that there's
billion
too much
a
regulation and
year.
not too much regulation. I invite you to come to my district, and I invite you to talk to the small credit unions. I invite you to talk to the supermarket owners. I invite you to talk to the energy industry. I invite you to talk to the agricultural
And
district.
they don't want to be regulated at all.
In my
Is that
district.
right?
No, they do. They're
No,
good
I think
stewards.
the thing is that they don't want to be
They want
regulated at all.
sensible regulation. And this administration and others have overreached so far that it's costing jobs, and that's why the American people are so fed up with Congress today.
I'm not hearing that they're so fed up with Congress today over regulation.
Well, then you're apparently
And
not
frankly, if
listening.
we're getting $90 billion back in the Treasury for me, it's okay with me. So I'd like to have unanimous consent, as you've already given.
Thank you. The gentleman from Georgia is recognized.
Thank you, Mr. Chairman. I just want to thank Mr. Marino for bringing the bill. It's easy, particularly in an election year, for folks to look at all the let's stop regulations bills as just a political shot here and there. You have a reputation as one of the most serious members of this institution. You and I were elected together 5.5 years ago, and no one would say that you have been about the business of making political points while you're here. They'd say you've been about the business of making a difference here. This is only going to go one way or the other. We can either seize all of this power back and start writing statutory law instead of empowering agencies to regulate, or we can work out a partnership with agencies so that we don't have to put it all in statute and that they can responsibly implement that. Could you tell me a little bit about the feedback you've gotten from job creators back home? One thing I have found that unites us on this committee is the desire to put Americans back to work.
An example is, as I stated, concerning credit unions. Credit unions are held to a standard that the 6 largest banks in the world are held to. They would hire more people, they could give more loans, but they have to have an individual or more responsible for looking at the regulations, satisfying the auditors who come in and stay there for weeks and end up finding nothing. I have no problem with regulation. We need regulation in this country, but it's to the point where it's putting people out of work in my district, and I'm pretty sure it's putting people out of work in both Republican and Democrat districts.
To your point, since you mentioned credit unions, had a credit union come to me the other day, said, Rob, 25% of the folks we have working for us now are in compliance. They're not in customer service. They're not in loan creation. They're not in small business development and assistance. They're in compliance. And to your point, as I recall, a majority of the members of this House, Republicans and Democrats, and a majority of the members of the United States Senate, Republicans and Democrats, wrote to the CFPB and said, it's crazy what you're doing to these credit unions. This is not what we intended when we passed Dodd-Frank, and yet the regulators have thrown up their hands and refused to act again on what the lawmakers insist was their intent. I know you're going to suffer the slings and arrows for bringing this bill, but it's critically important that we find this partnership going forward, and I'm grateful to you for doing it.
Thank you.
Mr. Chairman, I yield back.
Thank you, gentleman. Gentleman from Massachusetts recognized.
I think the administration is going to veto this. I don't think it's going to go anywhere. I don't think I have anything I want to add, so yield back.
Okay, gentleman from Texas. Gentleman from Ohio. No questions left on the Republican side, gentlemen. Okay, with that, gentlemen, thank you very much for your testimony. Again, if you have any written remarks, please leave them with our awesome stenographer, to quote our normal chairman here.
Thank you to the entire
Thank you
committee.
again for your testimony. Thank you, Mr. Chairman. I want to, that closes the hearing portion on H.R. 3438. I now would like to welcome my friend from Texas, the chairman of the Financial Services Committee, who's here today, Mr. Henserling. And is Ms. Waters here? Yes, I see that she is. And welcome the ranking member of the same committee, my friend from California. It's good to have both of you here.
Not pulling out. Oh, that's okay. That's fine. Sure. This is fine. Yeah. Thank you.
Our witnesses are here to offer testimony on H.R. 5461. Before we begin, again, as you conclude, any written remarks you have would be very helpful to us if you could leave with the stenographer or anything that you're going to be submitting for the record. And with that, I'll move to my friend, a good friend from the great state of Texas, and recognize him for any opening comments he cares to make.
Thank you, Mr. Chairman. The Islamic Republic of Iran has been identified by our government as both the world's foremost state sponsor of terrorism and a country of primary concern for money laundering by our U.S. State Department. It is also characterized by high levels of official corruption and substantial involvement of its security forces, particularly the Islamic Revolution Guard Corps, in that nation's business sector. Many members of Iran's senior political and military leadership have acquired significant personal and institutional wealth by using their positions to secure control of major portions of the Iranian economy. And much of Iran's terror activity is funded by vast sums of money that these same individuals personally control through foundation-like entities called bonyads, into which money from corruption is funneled. Because of this volatile mix of terrorism, corruption, and wealth, it is vitally important for us to clearly understand the assets held by Iran's powerful elite. That goal is well served by H.R. 5461, introduced by our colleague, Mr. Poliquin of Maine. This bill, the Iranian Leadership Asset Transparency Act, would require the Treasury Secretary to develop and post online a list estimating the funds and assets held by senior Iranian political and military leaders. Along with this estimate would be a description of how these officials acquired the assets and how these assets are being used. The report would be posted on the Treasury Department's website in English, but also translated into the 3 main languages used by the Iranian people, so the people of that nation might better understand the nature of their economy and how corruption is harming ordinary citizens. Under this bill, the report would also be in a form that is easily understandable and accessible to those in the financial or business sector who might be concerned about inadvertently doing business with an Iranian entity still covered by remaining sanctions. The Iranian government's tolerance of corruption limits realistic opportunities for foreign and domestic investment, particularly given the significant involvement of its Revolutionary Guard in many sectors of the economy. The Bonyads are foundations controlled by Iran's top political and military leaders, control an estimated 1/3 of Iran's economy, including large portions of its telecommunications, construction, airport, and seaport sectors. This control gives the Revolutionary Guard and its leaders vast amounts of funding to support terrorism at a time when the average Iranian citizen earns about $15,000 a year. The report under this legislation would cover roughly 80 individuals, including Iran's supreme leader, president, the 12 members of Iran's Council of Guardians, 42 members of its Expeditionary Council, and fewer than 24 senior military leaders. As I mentioned, the bill requires an estimate of the funds and assets held by these individuals, not a precise amount. Further, the proposal would allow Treasury to separately furnish any sensitive information to Congress in a classified form. Finally, the bill permits the administration to prepare the report using a wide variety of publicly available credible information, including commercial databases. Developing and keeping a current estimate of the funds and assets held by the top political and military leaders of Iran will also help financial institutions and private businesses comply with money laundering laws and also help them more carefully choose the businesses which would they do business. Lastly, H.R. 5461 is a bipartisan bill. It was approved by the Financial Services Committee on June 16th with a bipartisan vote 39-20. The Islamic Republic of Iran is identified as both the world's foremost state sponsor of terrorism and, again, a country of primary money laundering concern by our government. So the American people rightfully question the wisdom behind the Obama administration's decision to hand $1.7 billion in cash as ransom for the release of several hostages earlier this year, and that is why it is so important, again, Mr. Chairman, that we have this information for all. There's a lot of questions that the American people have, and this bill by Mr. Poliquin, H.R. 5461, would go a long way towards answering those questions. I look forward to answering any questions you or other members of the committee might have.
Thank you, Mr. Chairman. It's good to have your testimony. We'll now move to our distinguished ranking member and good friend from the great state of California, recognized for any opening remarks you care to make.
Thank you, Mr. Chairman. Ranking Member Slaughter and members of the committee for allowing me to share my views on H.R. 5461. This bill continues the Republican-led efforts to undermine the continued viability of the Iran nuclear deal, a deal that so far has delivered on its principal goal of blocking Iran's path to nuclear weapons for an extended period of time. The measure before us this committee today, the so-called Iranian Leadership Asset Transparency Act, is aligned in spirit with these previous misguided efforts to destabilize the nuclear deal. While we can all agree that increasing transparency into corrupt regimes is a laudable goal, the fact is that the report required under this bill would cause far more harm than good. Undoubtedly, the report would be seized upon by Iran as an intentional effort to discourage international investment in Iran, and this would be viewed by Iran as a violation of the express U.S. commitment under the nuclear deal not to interfere with the full realization of the relief provided to Iran under the accord. The major world powers who joined us in this agreement could also view the legislation as a bad faith measure by denying Iran the economic benefits it was promised in exchange for dismantling critical elements of its nuclear program, including unprecedented oversight of its ongoing civilian program. We removed the critical incentive for Iran to hold up its end of the bargain. In addition to my central concern that this bill destabilizes the Iran nuclear deal, I also share the administration's concerns that were this bill to become law, critical resources would be diverted away from investigations and the targeting of sanctions on Iran related to terrorism, human rights violations, and ballistic missiles. Meeting the requirements of this bill would place a very real strain on the Treasury Department and intelligence community, and we need to think carefully about the national security implications of diverting resources away from the Treasury investigators who are tasked with implementing current sanctions on Iran and uncovering illicit conduct across the globe. Moreover, since the reporting requirement in this bill would not be tied to any specific prohibition or legal action against the listed individuals, it would more likely increase confusion regarding compliance obligations rather than making remaining sanctions more easily understood, as the bill's objectives state. Proponents of this legislation have underscored the importance of its ability to show the people of Iran the corrupt practices in which their leaders are engaged. The reality, however, is that there is a profound trust gap between the United States and Iran, and with respect to the governments of both countries by the other's populations. Therefore, to the extent any portion of this report could actually be made public, since much of the most important parts of the report would likely be classified, it would do little to enlighten the people of Iran about their leaders. Rather, it would inevitably be rejected as U.S. propaganda by both the regime and by its people as a predictable attack on the country's government by the United States. In closing, in light of the bill's limited practical utility, its failure to meet its own stated objectives, its diversion of energy and resources away from investigations related to sanctions, and the destabilizing effect it would have on the Iran nuclear deal, I urge members to oppose this destructive and partisan legislation, and I thank you again for your consideration today.
Thank you. Let me just set aside the Iranian nuclear deal for a moment, since I don't know that that's specifically what this legislation is directed at. I actually don't think it is. But I asked my friend, the chairman, have you noticed any change in the behavior of the Iranian government since the Iranian nuclear deal?
Well, thank you for the question, Mr. Chairman. Yes, in many respects, it seems to have gotten worse as opposed to better. We know about the kidnapping of our sailors. We know again, there have been cyber attacks. I think it was 6 months ago that we had 7 Iranians who were indicted for cyber attacks against our major financial institutions, and the list goes on. So, no, I don't believe I have seen an improvement. And still, our government has stated that Iran, regardless of the nuclear deal, the JCPOA, remains the world's foremost state sponsor of terrorism. There is still a sanctions regime in place. And so this is simply a reporting requirement that we believe is important. And again, regardless of my friend, the ranking member's comments, this did receive Democratic support in our committee. And frankly, I would hope it would go on the suspension calendar, but unfortunately, we're taking up your time here today.
Well, I want to thank the gentleman and certainly our friend from Maine who authored the bill. I think it's very important. I think this is a regime that is fundamentally hostile to us, not because of what we do, but because of who we are. I think it's defined its existence in many ways as being hostile to the United States. And I think these efforts, however well-intended to try and establish a relationship, are almost certainly doomed to fail. But in this case, there are business interests that are woven into the fabric of the regime itself. And frankly, there are many members in this regime that have a financial incentive not to have a good relationship with the United States. So I think to the extent that that can be documented, verified, and exposed is a good thing. And we find there's nothing there, gosh, that would be wonderful too. But I suspect we'll find that there's some pretty unsavory financial connections at the highest levels of this regime that, again, benefit from continued tension. And gosh, if agreements and outreach could change behavior, we've certainly had multiple years of that effort on the part of this administration. And in my view, they've just not been successful because of the nature of the regime itself, not because we haven't tried. but because I think this regime is committed to hostility. So again, I want to thank you and your committee for bringing forward this legislation. I think it's valuable. With that, I'll go to the ranking member for any questions she cares to ask.
I'm pretty intrigued with this bill. We also know, by the way, before I start, that their centrifuges are all filled with concrete, so they're not going to be enriching any uranium anytime soon, which was one of the major parts of this plan. But I'm really intrigued with, I think I understood you to say that they were going to print something in 3 languages. Is that correct? And,
Yes.
And send it all over the world, or
Post it online.
post it? Are the Navy SEALs going to go in there at night and hammer it on a wall, or are you going to send it by mail, or how is it going to be accomplished that they would post this so that everybody could read it?
Well, it's also for the benefit of the American people as well, and for those
for
who
the
are trying
American
to.
people, not the Iranian people.
No, it's for both. And so, again, you were saying, how will it be received in Iran?
I mean, how are you going to get it there?
No, the Navy SEALs, I don't believe, will be posting.
No, but, well, let's be practical about it. How are you going to get them to put up your posters?
No, I don't. I will not be posting this. The SEALs won't be posting this.
Who
but-
will?
Well, it will be on the web. And so many people will be able to access it on the web.
Mm-hmm. Boy, that really sounds like a swell idea. But let me follow through with what Mrs. Waters said, and I think ought to
It
be
follows
answered.
many other reports that the
yeah.
government does.
That since most of that report will be classified, and it will, how do you expect people to take any advantage of it at all?
Well, frankly, I don't necessarily know that most of this will be classified. Frankly, there are a lot
Yes,
of
it
public
would.
databases, okay? That's what you assert. It's not what we discovered necessarily in our financial terrorism financing task force, and it's not what members of the committee concluded, but if there are aspects of that, we would certainly want the administration to report to Congress what those confidential and classified areas are. But there are also a lot of information on a publicly developed database. I just don't understand why trying to get more information about the leaders of the world's foremost terrorist financing, state-sponsored support of terrorism has become controversial in the United States Congress. I just frankly don't understand it.
Obviously, I think what I understand from what you're telling me is that the point is to inform Americans. You're pretty sure the Iranians are not going to put this up, right?
No, but there are other
Public
methods.
consumption.
There are
So-
other methods, Ms. Slaughter, that people will be able to access.
I'm curious
People
about
still
the 3
travel in and
languages.
out
Well, what
in
are the
Iran.
languages? Do you know?
English, Farsi, Arabic, and Azeri.
That's 4, okay. But the important thing, actually, what Ms. Waters asked that I think really needs to be answered is about the classification. And you don't see that as a deterrent to getting that kind of information out?
No, there is classified information and unclassified information, and the unclassified information will be made public, particularly, again, for American companies and individuals who may be investing, so they will be able to inform their own discretion about where they may choose to invest. And if you're asking me precisely the number of Iranians that will be exposed to this, no, I cannot be able to tell you right now how many Iranians will be able to be exposed to the information.
I would
But,
imagine
you
not
know,
many.
we never quite knew how many people were listening to Radio Free Europe or Radio Marti, yet it was an important mission of the United States to get that information to these people.
Well, I have no further questions, but I'd probably go back to the drawing board with that. I have a few questions here. Thank you.
Thank you, gentlelady. Gentleman from Georgia is recognized for any questions he cares to pose.
I'll be handling this on the floor tomorrow, Mr. Chairman, so I have no questions.
Gentleman from Massachusetts? Gentleman from Florida?
Briefly, Mr. Chairman, I would, you know, we do have some very serious problems here. I can't help but mention the Zika crisis because I don't think it's going to go away anytime soon, and we should be addressing it. The opiate crisis in our country is devastating, and we're not addressing it, and the government needs funding. In many respects, it would, in my view, be funny if it weren't so shameful that we're here talking about something that isn't going to go anywhere. Now, I took a tough vote on the Iran sanctions thing, and I'm one of the Democrats that voted against it. But I'll tell you this is nothing more than a one-chamber election year messaging piece that needlessly diverts resources that are needed to track actual violations that would lead to sanctions. And let me be facetious but truthful. I wish we had spent as much money trying to learn about, or were as circumspect in trying to learn about Karzai in Afghanistan, who and where his money is, and his brother, and all the rest of them. I wish we had spent some of our time with Alaki in Iraq, who's probably in London in luxury, trying to figure out where they were. And as a matter of fact, I wish we would be circumspect about our candidates for presidency here. If we can find out about Iran's wealth, then we ought to be able to find out about Mr. Trump's wealth. That would at least kind of balance it a little bit. But all things considered, it's a messaging bill, and I hope my message trumps it.
Vice President of U.S. Cheney was involved in investigating.
I think we're being joined by other members. Okay, are there any further questions? In that case, the hearing portion of this session of the Rules Committee is closed. And I want to thank both our witnesses for their testimony. Remind them if they have any prepared remarks they care to leave, please do so with our stenographer. It'd be very helpful. Thank you very much. You guys ready? Okay, the chair will be in receipt of a motion.
Thank you, Mr. Chairman. I move the committee grant H.R. 3438, the Review Act of 2016, a structured rule. The rule provides 1 hour general debate equally divided and controlled by the chair and ranking minority member of the Committee on the Judiciary. The rule waives all points of order against consideration of the bill. The rule makes an order as original text for the purpose of amendment, the amendment in the nature of a substitute recommended by the Committee on Judiciary, now printed in the bill, and provides that it shall be considered as read. The rule waives all points of order against that amendment in the nature of a substitute. The rule makes an order. Only those further amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. The rule provides one motion to recommit with or without instructions. Section 2 of the rule provides for consideration of H.R. 5719, the Empowering Employees Through Stock Ownership Act. Under a closed rule, the rule provides 1 hour debate equally divided, controlled by the chair and ranking minority member of the Committee on Ways and Means. The rule waives all points of order against consideration of the bill. The rule provides that the amendment in the nature of a substitute recommended by the Committee on Ways and Means, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides one motion to recommit with or without instructions. Finally, Section 3 of the rule provides that it shall be in order at any time on the legislative day of September 22, 2016, or September 23, 2016, for the Speaker to entertain motions that the House suspend the rules as though under Clause 1 of Rule 15, the Speaker or his designee shall consult with the minority leader or her designee on the designation of any matter for consideration pursuant to this section.
Is there any discussion or amendment?
Yes, please.
Gentlelady's recognized.
Mr. Chairman, I recommend the amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 5719 by Representative Crowley. Number one, which would offset the bill's more than $1 billion cost by raising the oil spill liability trust fund tax by 2 cents per barrel. Mr. Chairman, there is bipartisan support for the underlying policy in H.R. 5719, but it would be difficult to support another unpaid-for change to the tax code when Mr. Crowley would take care of that. So unless we adopt an offset, the House Republicans will have passed nearly $34 billion in unpaid-for tax cuts in just the last week alone. This is the same kind of reckless fiscal policy that turned our budget surplus in the late 1990s into a deficit in the early 2000s. Mr. Chairman, I know when I finish you will respond by saying this amendment is not germane to the bill, but Mr. Chairman, we are the Rules Committee and we often have the authority and use it to waive the germaneness rule if the situation requires it. In this instance, I think we cannot afford to waive this rule to make this offset in order, and I ask for a yes vote.
Well, gentlelady's right, it's not germane, but is there any further discussion on the amendment?
Well, let me just repeat what I said. You have already, you will have passed $34 billion in unpaid-for tax cuts in the last week. This will give you a chance to erase a little bit of that with Mr. Crowley's bill, which causes precious little harm. 2 cents a barrel on oil is not anything so devastating that we cannot live with that.
Appreciate the gentlelady's point. I will point out that it is the oil spill liability fund. That's what it's for, not for this. It's actually a tax for a specific purpose.
I would have rather taken it from the $20 billion that we give the oil industry.
Well, actually, we don't give the oil industry anything, but that's a debate for another day. It's given you extraordinarily cheap oil and gas and plentiful supplies. So, but, you know, again, on this particular item, we'll have a vote. We'll see how people feel about it. And then if any of my Democratic colleagues don't want to support the tax cut, they'll have that opportunity on the floor. But we'll see how many of them vote for this, quote, unoffset tax cut. But with that, are there any further comments or questions? Hearing none.
Did you want to speak? Oh, okay.
Great. Hearing none, the questions on the amendment. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. The opinion of the chair, the noes have it. The amendment's not agreed to.
Roll call, please, Mr. Chair.
Roll call has been requested.
Mr. Sessions, Ms. Fox? No. Ms. Fox? No. Mr. Cole, or
No.
excuse me, Mr. Woodall? No. Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? No. Mr. Collins, no. Mr. Byrne? No. Mr. Byrne, no. Mr. Newhouse? No. Mr. Newhouse, no. Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report.
3 yeas, 8 nays.
Amendment's not agreed to.
Mr. Chairman?
The gentleman from Massachusetts recognized.
First, I want to ask unanimous consent to insert a statement by Representative Anna Eshoo on H.R. 5719 in the record, and one by Congresswoman Sheila Jackson Lee on H.R. 3438.
Without objection.
And I have a couple of amendments. The first one is I have an amendment to the rule. I move the committee grant H.R. 3438 and H.R. 5719 each an open rule so that all members have the opportunity to offer amendments to the bills on the floor.
Is there any discussion of the amendment? Hearing none, the question is on the amendment. All those in favor signify by saying aye.
Aye.
All those opposed, no. No. The opinion of the chair, the noes have it.
Roll call, Mr. Chairman.
A roll call has been requested.
Mr. Sessions, Ms. Fox? No. Ms. Fox, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? No. Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter?
Yes.
Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings? Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 8 nays.
The amendment's not agreed to, and without objection, the motion to are there any further
Yeah,
amendments?
Mr. Chairman, I have an amendment to the rule. I move the
Gentleman's
committee make
recognized.
an order and give the necessary waivers for the amendment to H.R. 3438 by Representative Jackson Lee, number 4, which would prevent frivolous lawsuits from automatically postponing the implementation of any rule that prevents, responds to, or mitigates the adverse impacts of public health emergencies like the outbreak of Zika and the Ebola virus.
Is there any further discussion on the amendment? Hearing none, the question's on the amendment. All those in favor signify by saying aye.
Aye.
Those opposed, no. No. The opinion of the chair, the noes have it.
Ask
The
for a roll
amendment's
call on that, Mr. Chairman.
roll call has been requested.
Mr. Sessions, Ms. Fox?
No.
Ms. Fox, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter? Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 8 nays.
Amendment's not agreed to.
Mr. Chairman?
Gentleman from Florida is recognized.
Thank you, Mr. Chairman. I have an amendment to the rule. I move the committee make an order and give the necessary waivers for the amendment to H.R. 3438 by Representative Conyers, number 1, which would prevent frivolous lawsuits from automatically postponing the implementation of any rule that reduces the level of lead in drinking water.
Is there further discussion on the amendment? Hearing none, the question's on the amendment. All those in favor signify by saying aye.
Aye.
Those opposed, say no. The opinion of the chair, the noes have it.
Mr. Chairman, I ask for a roll call.
A roll call has been requested.
Mr. Sessions, Ms. Fox?
No.
Ms. Fox, no. Mr. Cole, or excuse me, Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter? Ms. Slaughter, aye. Mr. McGovern?
Aye.
Mr. McGovern, aye. Mr. Hastings?
Aye.
Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report the total.
3 yeas, 8 nays.
Amendment's not agreed to. Are there further amendments? Seeing none, we'll move to the full bill, or the rule. All those in favor say aye. Aye. Opposed? No. The amendment's agreed to. Excuse me, the motion's agreed to. We have any further business? Gentlelady's recognized.
Mr. Chairman, I move the committee grant H.R. 5461, the Iranian Leadership Asset Transparency Act, a structured rule. The rule provides 1 hour general debate, equally divided, controlled by the chair and ranking minority member, Committee on Financial Services. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule makes in order only those amendments printed in the Rules Committee report. Each such amendment may be offered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided, controlled by the proponent and an opponent, shall not be subject to amendment, shall not be subject to a demand for division of the question. The rule waives all points of order against the amendments printed in the report. Finally, the rule provides 1 motion to recommit with or without instructions.
Is there any discussion or amendment?
I have an amendment.
The gentlelady's recognized.
I move the committee grant H.R. 5461 an open rule so that all members have the opportunity to offer amendments to the bill on the floor.
Is there any further discussion on the amendment? Hearing none, the question's on the amendment. All those in favor signify by saying aye.
Aye.
All those opposed, no.
No.
The opinion of the chair?
Roll call, please.
And the noes have it, but
Roll call, please.
roll call has been requested.
Mr. Sessions, Ms. Fox?
No.
Ms. Fox, no. Mr. Woodall? Mr. Woodall, no. Mr. Burgess? Mr. Burgess, no. Mr. Stivers? Mr. Stivers, no. Mr. Collins? Mr. Collins, no. Mr. Byrne? Mr. Byrne, no. Mr. Newhouse? Mr. Newhouse, no. Ms. Slaughter?
Aye.
Ms. Slaughter, aye. Mr. McGovern? Aye. Mr. McGovern, aye. Mr. Hastings? Aye. Mr. Hastings, aye. Mr. Polis? Mr. Chairman?
No.
Mr. Chairman, no.
Clerk will report.
3 yeas, 8 nays.
The amendment's not agreed to. Can we, are there any further amendments? We'll move to the gentlelady's motion. All those in favor say aye.
Aye.
Opposed?
No.
It appears the ayes have it.
On what? What was that? We just
Okay,
passed the rules.
One moment. Managers, on rule number 1 will be Mr. Collins of Georgia. On rule number 2 will be Mr. Woodall, also of Georgia.
On 5719 and 3438, Mr. McGovern. On 5461, Mr. Polis.
Gentleman had a question?
Yes, and that is whether or not we're meeting any additional.
It's my understanding we're scheduled for a meeting tomorrow. Is that correct?
Tomorrow.
There we go. Next meeting, we're scheduled to meet on H.R. 5931, a bill related to ransom payments to Iran, tomorrow at 3 p.m. We all eagerly await news out of the Senate on the CR, and the committee will be prepared to respond in an expeditious way. With that, the business of the committee is concluded for this evening. We're adjourned.